attorneys, and I spoke to Mr. Mbao to give me the number of Geraldine Berger, who I know and have been introduced since the beginning of this proceedings to be the person, to be the contact person. For the entire day, I was not given those numbers. This morning, I spoke to the main director of DM Attorneys himself, and I indicated my disappointment that their law firm, since yesterday, I've been communicating with one of the officials just to get through to Geraldine Berger, and I could not get those details. I was quite very happy when I now deal with the main director, and we started exchanging since this morning. We're traveling with one car. When we were just about to arrive, and I was requested to have a copy of the High Court, I indicated to Mr. Ngoato that for some reason since this morning, my phone cannot open PDF documents. So I'm waiting for Mr. Maleka to come outside court. I'm standing outside court so that I can send the necessary documentation to him. Unfortunately, in this particular instance, there was never any malice or any intention on our side to disrespect the commission. I've been up since 6 o'clock this morning dealing with this particular matter. We left our office 2 o'clock this morning.
Mr. Ngoato, I will say this, and I do not want us to engage any further on it. What you say from where I'm sitting are excuses that are totally unacceptable. I maintain what I said earlier, which is that knowing that you had to be here at 9:30, there was no reason for you to attend to a minor, yes, important administrative issue that could have been attended to by anybody. Totally unacceptable. The discussion is closed.
Well, we apologize for that, Commissioner.
Sorry?
We apologize for that.
Thank you.
Thank you.
Yes, Mr. Chaskalsin?
Chair, Mr. Ngoato was going to move a postponement application.
Yes. Mr. Ngoato, we have before us your postponement application. Can you proceed to move it, please?
Indeed. Commissioner, I must appreciate and thank the Commission for having granted us the postponement last week. And indeed, we definitely used off the time to the best of our ability as was granted since last week. However, since we started finalizing the documentation, certain things really cropped up and showed and changed the direction that we were taking, which therefore since necessitated this application. As it's commonly known, we are the creatures of instruction. It's our client's instruction then to bring an urgent application in the Higher Court, purely and solely for two reasons. As the Commission is in possession of the papers, I take that the papers might have been read, and I apologize that they've been submitted to the Commission almost on the 11th hour. The first reason, Commission, is the same reason, one of the reasons that we mentioned last week, that the applicant, before he could even make his first written submission to the Commission on the 17th of December, an interim report was already been issued, which we fully understand and correctly so in terms of section 10.4 of the terms of reference, that the Commission is entitled to do so. But 2 days before he could even make his first written submission, an interim report has already been issued, which had recommendations and findings and recommendations against him. Unbeknown, and obviously we do not have access to that particular interim report, but just a day before our appearance on the 30th of January, which is last week, Friday, the state president publicly announced that he accepted the same report, and therefore an announcement was made that he needs to be charged. It is on the basis, that's the first reason, it's on the basis of that is of the view that even though at the Commission he is a witness, not an accused, but whatever he may be able to say as a witness at the Commission he may incriminate himself, which will be a violation in terms of section 35(3) of the Constitution. The second aspect that made us to then make the application to the High Court, Commissioner, is that in perusing the WhatsApp charts, the nature of the WhatsApp charts and the manner in which they've been extrapolated, it only shows outgoing and incoming. Even messages that were not originated by him, but he received them when they were forwarded to him, appears to be that he's the originator of the messages, which now distort the narrative and the version and how things are in terms of those messages. And as a result, that will then necessitate that he now gains access. Oh, I apologize. That will now necessitate that we look into how the messages were extrapolated in terms of, from his phone, in terms of, from the time it was
Feel free to either put it on silent or switch it off. Don't feel any pressure not to do that.
Mr. Commissioner, it's not even my phone, it's Mr. Maleka's phone, and I don't know his password or
Okay,
his
all right.
pattern, how to close it off.
No, that's-
So mine is here, and this is Mr. Maleka's phone. Is Mr. Maleka's phone ringing?
All right, thank you.
So, in the manner in which how this, the chain of evidence, or the chain from the time his phone was taken.
Is that Mr. Maleka? Please go across.
Sorry, sorry. Yeah.
Are you no longer comfortable to support your post the way you did last week, Mr. Maleka? All right. Please continue. I'm sorry about the interruption, Mr.
Thanks,
Ngoato.
Commissioner.
Yes.
So the manner in which the charts were downloaded or extrapolated from his phone leaves much to be desired, which appears to be a violation in terms of how the evidence is being presented, because it doesn't show the messages that are forwarded. It doesn't show that he received it as being forwarded to him, but it shows as if he's now the originator. And some key people or chats that he had with other people are not included in that. And I quite understand that the evidence leader said there were certain messages that are not of interest. But for a consistency basis, in particular, he's been much more in communication with one particular general, and as opposed to the other. But and the things that they were discussing with the other are not included. That shows a wrong narrative or misplaced the whole view of the situation. And as a result, it was my clients obtained a legal opinion from 2 SCs, senior counsels, who then are the ones that are currently working on the application in the High Court, with a junior counsel based in Durban. These had to have took place as a matter of one day, having to go through this thing. And it is on that basis that if he is to come before this commission, whatever he says may not change, because of before he could make the first statement, an interim report was made. Before he could even appear, the president has already accepted that. So whatever he comes here and says may not change the narrative, and more likely that he will incriminate himself in any answer that he gives. And it's on that basis that that the applicant decided to launch an application in the High Court to restrict this commission, not to compel him to appear and not to compel him to answer any questions until pending the finalization of that application in the High Court. Thank you, Mr. Commissioner.
Thank you, Mr. Ngoato. Mr. Ngoato, I read, because I received the application only this morning, I read it hurriedly, and I may have either missed or misread what I'm about to raise. I don't remember in the affidavit a point being made about WhatsApp chats that appear to have been initiated by the witness when in fact they were not. Did I miss that? Or is this something you are stating for the first time from the bar, as it were?
Commissioner, I was just trying to elaborate on the reasons that I
Wait,
given. Because
then
the first ground of him
Yes.
wanting the High Court to interdict is that his WhatsApp chat should not be displayed, because those WhatsApp chats are not correct. They are incorrect in the manner in which they have come from, because the entire bundle of documents, they only show outgoing and ingoing. Even the WhatsApps that somebody forwarded to him, and he sent it to somebody, it only shows that he's the one sending and making him the originator, while he's the actual fact not the originator of the message.
Okay. With the exception of what you are raising from the bar, my reading of the application is that the only new thing that's being raised in the application affidavit is the issue relating to Section 35 of the Constitution. The rest is something that the applicant ought to have raised in his postponement application moved last week. Do you agree with me?
May you please repeat?
I'm saying I read the application, today's application, to raise only one new issue, leaving aside the point that you are making from the bar. And that one new issue is the issue relating to Section 35 of the Constitution, the right to a fair trial in the context of a criminal trial. That's the only new thing that I saw in my reading of the application. The rest are issues that the applicant ought to have raised in his postponement application that was moved last week. What's your comment on that?
If I understand you, Commissioner, is that the things that are mentioned in the current application, is the Commissioner saying most of them are the things that were raised in the previous application?
Are the sort of things that could and ought to have been raised in last week's application. The exception is the Section 35 issue. That, on my reading, is the only new issue.
I differ, Commissioner, and maybe let me explain myself in terms of maybe try to find out common ground between the two. When we moved the application last week, it was simply because that we had not had time to peruse. Now, the time to peruse obviously goes hand in hand in the manner in which we received the documentation. But on further perusal of the matter, these things now become very clear. That Section 35, subsection 3 rights will be highly affected. But it all emanates also in terms of how he has been served right from the beginning. So there's a lot that starts and giving context from the beginning of how he received the notices and the ultimate aspect, if I'm making myself clear.
Yes, Mr. Ngoato.
And maybe just to conclude, Commissioner, we obviously gave the client a legal advice in light of the Zuma case, and I'm quite aware that the Commissioner is quite vested with that case, if not that participate in that case. And we had to distinguish between the rights of an accused as opposed to the rights of a witness. Because you could not invoke the right to remain silent because he's not an accused in here, he's actually a witness. But as a witness that is already been charged, is more likely to incriminate himself, which now prejudices his rights, and hence the focus